If you are in the process of buying or selling a property, it is very important to make sure that you understand the offer to purchase document and the meaning and consequences of the various clauses contained in it. The offer to purchase, commonly referred to as the OTP, contains all the terms and conditions of the sale that are agreed upon between the buyer and the seller. Please remember that this is a legally binding document, so do take it seriously. Otherwise, the home buying process, which should actually be an exciting life event, could turn sour. So I'm going to run through a few of the most common clauses that you will find in an OTP or offer to purchase document. So keep watching to make sure that you're not caught off guard by any of the clauses and ensure that you have a good understanding of what each clause entails. My name is Andre Forster from eXp Realty South Africa. Myself and my wife Lydia have been in real estate in Durbanville and surrounds since 2005. And we are passionate about making the whole buying and selling process a pleasant and memorable experience for all our clients. Please remember to like and subscribe to all our social media channels to make sure you receive future updates and useful information and advice. Please keep in mind that this is a specific offer to purchase, and these are just examples of the clauses you'll find. It's always very important to read the specific offer to purchase that you are signing, as different agencies might have different variations of the wording. It's also very important that you do read through everything carefully. And if you do have any questions, you're welcome to contact us at any time. I'm going to be covering quite a few topics in this video. So just for ease of use, for later reference, you will see I'm going to be putting up an index over here where you can see at what specific stage in the video you will be able to see what topic. So for later reference, you can just forward to the topic that you're actually interested in or that you want an explanation about. The parties. The offer to purchase must always identify the parties involved as well as the property involved. So both buyers and sellers' full names and identity numbers must appear on the OTP. Of course, if either party is a legal entity, such as a company or a closed corporation or a trust, then the full registered name of that entity and the registration number of the entity must also be specified. And in that case, of course, the person representing the company or CC that's authorized to do so must also be properly identified. Then the property has to be identified correctly. There's always a common description, which is the commonly known street address. Let's say, for example, 123 Smith Street in Durbanville. But more importantly is the legal description of the property, which is very important as it appears on the title deed. So in the case of a freestanding property, it will be an earth number and a township. For example, earth number 123, Durbanville, which is the registered township. Or in the case of sectional title property, there will be a sectional scheme name, a sectional scheme number, as well as the section number of the unit that's being sold. The purchase price. Very importantly, of course, the offer will have to specify the purchase price, which is the price that the buyer is offering to the seller for the property. Then it must also specify the terms and conditions upon which this purchase price is going to be paid. Most commonly, the purchase price will be made up from any one of the following or a combination thereof. If the buyer has a cash amount available or a cash deposit, that must be specified, and it must also be specified by when it is payable to the conveyancer. Alternatively, the buyer could provide bank guarantees from the financial institution where his funds are held. Then that must also be specified, as well as the time by which the guarantees must be provided to the conveyancer. If the sale is subject to the purchaser obtaining a loan or bond for the purchase price, or even a portion thereof, that amount will also have to be specified in the bond clause, as well as the time period which the purchaser will be allowed to get the loan approved. If the purchaser needs to sell his existing property in order to get funds to purchase this property, in other words, the purchase is subject to the successful sale of the purchaser's property, then that will also have to be specified in a separate clause, and it must also specify the time period that the purchaser will be allowed to get his property sold. The OTP must also specify what guarantees or undertakings the purchaser will provide for the purchase price and by when. So very importantly, how the property will be financed can differ from case to case, each case on its own merits, but it must all be very clearly specified, and there must be time limits attached to each. Transfer. Then there will be a clause covering the transfer and registration of the property, specifying when transfer should take place and who the transfer attorneys, also called the conveyancers, will be responsible for the process. Very often this will simply state that transfer must take place as soon as possible. Sometimes, however, the parties will agree on a preferred date for transfer to take place. But bear in mind, though, that this date cannot be guaranteed. There are various factors and processes and role players involved that could cause delays. So it's not a guaranteed date, but it's a date which is aimed for. This clause will also specify that the transfer duty and other costs generally are paid by the purchaser unless otherwise agreed. And if the purchaser is utilizing bond financing, it will also specify that the bond registration costs need to be paid by the purchaser. Then there's a clause dealing with the occupation date and occupational rental. This often causes quite a bit of confusion if not understood completely. So as mentioned before, we have the registration date or transfer date, which is the date on which the parties have agreed they would prefer registration to take place. Or of course they may have agreed that registration must take place as soon as possible. The occupation date could be a different date to the registration date. Sometimes it is simply agreed that occupation will be given to the purchaser on the date of registration of transfer. In other words, simultaneously with when transfer happens in the deeds office. That simplifies matters and that is easy. But as mentioned before, the registration date cannot always be pinpointed or guaranteed. So if occupation is going to be given on registration, the buyer and the seller are not absolutely guaranteed exactly when that will be. And sometimes a purchaser will need to know exactly when he or she is going to be moving. For example, the purchaser might have to give notice where he or she is renting at the moment, or they just want to be able to arrange a moving company for a specific day. And to make planning easier, the parties would then like to specify a fixed date of occupation so that they all know exactly when the move can take place. In that case, the parties will also need to agree on an occupational rental amount. So if the property is not transferred by the specified occupation date, then the purchaser will be allowed to move in as agreed, but he will have to pay occupational rental to the seller from the occupation date until the date on which the property registers in his or her name. So a specific monthly rental amount will be agreed on for this occupational rental, and the purchaser will pay that from the date of occupation until date of registration. It is also very important that the occupation clause must mention whether occupation is being given to the purchaser subject to any existing tenancies or whether the property will be vacant on the date of occupation. So if it is subject to existing tenancy, which means the buyer is going to take over the existing tenant that is already in the property, I must advise that you first get a copy of the current lease agreement and read through that carefully, as you will be taking over that lease agreement as landlord from the date that the property registers in your name, and you will be bound to the conditions contained in that lease agreement. So please make sure that you familiarize yourself with the content of the lease agreement. Then there are suspensive condition clauses in an OTP. Suspensive conditions in an offer to purchase. A suspensive condition is, in layman's terms, a condition which basically makes the offer still hang in the air, subject to a certain event occurring in future. The most common suspensive conditions are usually there to protect the purchaser. Firstly, the most common suspensive condition is the bond financing clause. This clause usually states that the offer will be subject to the purchaser obtaining a loan or a bond of a certain amount, and it will also state that it has to be obtained by a certain date. So in other words, if the purchaser cannot for some reason obtain a bond and the banks don't grant him the bond, then the purchaser doesn't have to purchase the property. So as I mentioned, that clause is there for the purchaser's protection, as he will possibly not be able to purchase the property if he is not able to secure such a loan. So until that suspensive condition is met, he actually gets the bond for the required amount, the transaction is hanging in the air. If and when, of course, the loan is approved, then the transaction can proceed. Another example is where the purchaser needs to sell a property in order to be able to finance this transaction. So we call that a subject to sale suspensive condition. So the offer is made subject to the successful sale of the purchaser's property. He needs to sell that property to obtain funds for the purchase of this property. He probably also needs to cancel the bond on that property in order to qualify to have a bond registered on this property. So the purchaser and the seller will agree on a certain time period for the purchaser to sell his property and to get all his ducks in a row on that side in order to buy this property. So that again is a suspensive condition for the protection of the purchaser. And if for any reason this condition is not fulfilled timelessly, then this transaction falls through and is cancelled. Unless, of course, the parties agree on an extension for that condition to be fulfilled. Those are just the two most common examples of suspensive conditions. There can be a multitude of suspensive conditions in an offer to purchase. For example, if the purchaser is located far away, but he likes what he sees of a property online, then before traveling all the way to view it, he would rather like to be sure that all the terms of his offer are going to be accepted by the seller before he actually does the traveling to go and look at the property. So in that case, the parties could agree to insert a clause into the offer to purchase stating that the offer is suspensive upon the condition that the purchaser will still need to view the property and find it to be to his satisfaction. So the purchaser would then submit an offer to the seller. They would agree on the price and all the other terms and conditions, but it would still be subject to him viewing the property, of course, within a certain time period. There can also be suspensive conditions in favor of the seller. For example, the seller might sell the property to the purchaser but insert a clause stating that it is subject to the seller successfully purchasing another property that is to the seller's liking. Very important, all clauses must always state exactly what needs to happen, who is responsible for it happening, and by when it must happen. Then we get the famous 72-hour clause, or otherwise known as a continued marketing clause. This clause really is often misunderstood. The 72-hour clause specifically relates to suspensive conditions in an offer to purchase. So as we have discussed, when there are suspensive conditions in an offer to purchase, such as the buyer still having to obtain a bond or the buyer still having to sell his property, then while the buyer is trying to fulfill those conditions within the time period that was agreed upon, the seller does not really know whether his property is actually sold. The seller could find out at the end of those allowed time periods that the buyer was maybe not able to obtain the bond or he was not able to successfully sell his property. So in those situations where the seller is not yet guaranteed that his property is sold, the seller can't be expected to just simply stop marketing his property while the buyer is busy trying to fulfill his suspensive conditions. So by inserting a continued marketing or a 72-hour clause in the sale agreement, the seller is given the right to continue marketing his property while those suspensive conditions are still in the air. So the basis of the 72-hour clause is this. While there are still suspensive conditions on the purchaser's side, the property can be marketed by the seller and he can also accept further offers, which are then often referred to as backup offers. So once he's accepted the first offer, that offer remains first in line, but he is then entitled to accept other offers as well. So if, let's say, a second offer comes up with the required cash or his bond is fulfilled and all other suspensive conditions are fulfilled, so in other words, the second offer becomes an unsuspensive offer with no more suspensive conditions attached thereto, or then where the suspensive conditions have already been fulfilled. So then the seller knows that the second buyer is in a position to buy his property. So the seller then has the right to give the first buyer notice. Generally, it's a 72 hours notice period, which is the common name for this clause, but the notice period can differ. You would have to read your specific contract to see what the time period is there. So once the second buyer has fulfilled all his conditions, the seller will then give the first buyer this written notice stating that he has received another offer and that the second offer has no suspensive conditions attached to it. The seller would usually also have to provide proof to the first buyer that he actually has such an offer. The first buyer will then have 72 hours or whatever period is specified in that first offer. He will have that time period to fulfill all suspensive conditions in his offer to purchase. Or he could waive the suspensive conditions, which means he is binding himself unconditionally to that offer and declaring himself financially able to fulfill all his obligations. This waiving is very dangerous to do unless you're absolutely sure that you are really in a position to buy the property. If, however, the first buyer is not in a position to do that within the 72-hour period, then that first offer will be cancelled and become null and void. And then the second buyer's offer would be successful because his finances are all in place. It is very important with 72-hour clauses to read the wording carefully because they really can vary from one sale agreement to another. For example, the period can differ. It can say 72 hours or it could say 5 days. It could also be, say, working days and exclude Saturdays and Sundays and public holidays, or it could simply be calendar days, in other words, just 3 days. And then it includes Saturdays and Sundays and public holidays. Also, the terms on which the seller is allowed to give the first buyer notice will be specified in there and could also differ, and so on and so forth. So if you ever have any confusion or are uncertain about a 72-hour clause, please feel free to contact us. I will do my best to help you and advise you. And if I cannot help you, I will always refer you to an attorney who can. Fixtures and fittings. Any offer to purchase should deal with fixtures and fittings. In the absence of a list of fixtures and fittings that are included or excluded from the sale, it defaults to common law. And there are many court cases which deal with this. So usually a property is sold inclusive of all permanent fixtures and fittings. And if nothing is specified, then we have to go by the legal definitions of that. And this often causes a lot of confusion and very often leads to disputes between buyers and sellers where they had different expectations from each other. So we generally ask sellers right up front before marketing the property. We draw up a list of fixtures and fittings and specify what will be included and what will be excluded. This the seller then signs, and then of course the buyer will then also sign that as an annexure to the offer to purchase later on. So then there is no confusion. In this manner, everybody knows what is included, what is excluded, and there's no confusion later on, so it shouldn't lead to any disputes. Then there is a clause dealing with brokerage, or commonly referred to as agent commission. So this clause will state what commission the property practitioner is entitled to. It will be stated either as a rand amount or otherwise as a percentage of the purchase price. But it should clearly state whether it is inclusive of that or exclusive of that, so that there's also, again, no confusion later on. Then every contract will have a breach of contract clause. Every agreement will contain this, and this clause specifies what will happen in the case where either party is in breach of contract. In other words, where one of the parties does not timeously adhere to any specified terms of the agreement. It will state what process must be followed, what the consequences will be, and also what rights the other party has. Then there will be a few clauses with certain warranties and undertakings made by the parties. The purchasers would have to warrant that all their tax affairs are in order with SARS. This is very important because obviously SARS will be notified of the transaction when it comes time to pay the transfer duty over to SARS. And if any of the parties are in default at SARS and owe SARS money, SARS could put a halt to the transaction. So we need to know up front and at least just get an undertaking from the purchaser that all his tax affairs are in order. The seller, on the other hand, will have to make sure that all municipal rates and taxes are paid and are up to date at the municipality prior to the date of registration of transfer. These days, the deeds officers do require a rates clearance certificate from the municipality. So the municipality will issue rates figures up front and then demand an upfront payment from the seller, which then covers a few months' worth of rates and taxes and services, so as to ensure that the seller will not be in arrears when transfer takes place. So the conveyancers will take care of this and obtain a rates clearance certificate from the municipality prior to registration of transfer. Then there is a clause dealing with effective cause. Both parties will need to warrant in the offer to purchase that the agency involved is indeed the effective cause of the sale. That will help, of course, to avoid confusion and any possible disputes later on. So we ask all parties to declare that we were the effective cause of the sale so that there will be no commission disputes later on. Then there should be a clause dealing with the residential status of the seller. The seller is required to declare his residential status, in other words, whether he is a resident of South Africa or not. This is important for tax purposes, as there is withholding tax applicable if a property is sold for more than a certain amount and the seller is a non-resident. So this is just a measure that SARS has brought in to ensure that they are not done in with their taxes. So if a seller is a non-resident, then the attorneys will need to withhold a certain percentage of the sale amount and pay that over to SARS in lieu of possible taxes which could be owed by the seller. Right, then all the compliance certificates. The seller will be required to get certain compliance certificates for the property, depending on what installations are present on the property. Some of these certificates are required by law, and others are simply agreed upon between the parties in the sale agreement. Firstly, the electrical compliance certificate. This is a legal requirement. The seller will have to get an electrical compliance certificate from an accredited contractor and provide this to the conveyancers prior to registration of transfer. In Cape Town, we have a water bylaw, which states that property owners would have to get, we just call it a water installation certificate, sometimes called a plumbing certificate, which covers certain aspects which are stipulated in the water bylaw. So any seller within the city of Cape Town, it is a legal requirement to get a water installation certificate as well. Then you get the electrical fence certificate. That's if there is an electrical fence on the property, and this is also a legal requirement. You'll also get a gas installation certificate for any gas installations on the property. There are certain standards that gas installations have to adhere to. So a seller would have to get a certificate from an accredited contractor regarding any gas installations that are present on the property, such as gas stoves or gas fireplaces, etc. Then finally you get the beetle certificate, which is about any wood-boring insects in any of the woodwork on the property. So it would state that the property is free of any such wood-boring insects. This is not a legal requirement, but it's often agreed upon in an offer to purchase that the seller would obtain one of those. Then the Voetstoots clause. Right. One of the most important clauses to understand, the Voetstoots clause. We can go into depth on this clause, and I've actually got a whole article on it on our website. But in short, the Voetstoots clause means that the buyer is buying the property as it is, with all defects, both patent and latent. Patent meaning defects that you can clearly see, and latent defects are those that you cannot easily see. The only time a purchaser will be able to hold a seller liable for any defects in the property is if there are latent defects, which the buyer could not see with a reasonable inspection. And the buyer can prove that the seller purposely did not tell him about these defects, although he was aware of them. In other words, the seller was aware of those defects, but did not tell the buyer about those defects, so he did not declare them to the buyer. To assist sellers in this respect, we have a property condition report, which we require the seller to complete and sign, where we ask the seller very specific questions about the condition of the property, and to declare any defects that they are aware of based on those questions that we ask them. We then also attach this as an annexure to the offer to purchase, and the purchasers must also sign that in acknowledgement. Right, so that was a brief explanation of the most important clauses in our offer to purchase. There are a few other general clauses in there as well, but they're pretty self-explanatory. But of course, if you have any questions about any of the clauses, please don't hesitate to ask. I really hope this helped you. Please refer back to it and make sure you know what you're signing when you are signing an offer to purchase, whether it be through us or any other agency. All too often, buyers and sellers seem to simply sign on a dotted line without really understanding what they have signed, and later that leads to unnecessary disputes because of their ignorance. And these are disputes that could have been avoided. So it's important to please make sure that you do understand what you're signing before signing it. And if you have any questions, just please ask. If there's ever a question that we cannot answer, we will refer you to a legal professional and get the right answer for you. And of course, also to stay updated in future, please like and subscribe to all our channels on YouTube, Facebook, Instagram, LinkedIn, and of course TikTok. You can also visit our website, propla.co.za, which features a frequently asked questions section that answers many property related questions. If you need any advice, please get in touch. We'd love to chat with you. Or of course, if you are considering selling your property, let's discuss a customized marketing plan tailored to your specific needs. In the meantime, take care, stay safe, and God bless.